Here's a question Congress might ponder. What does Section 8 of the National Voter Registration Act mean when it requires its states must, quote, conduct a general program that makes a reasonable effort to remove the names of ineligible voters from the official lists of eligible voters, unquote. According to federal courts, unfortunately, now it means next to nothing. That isn't what Congress intended in 1993. Courts have unfortunately interpreted the language passed by this Congress to find the mere existence of a list maintenance program is what matters, not the program's effectiveness. Panels of the Sixth Circuit and the 11th Circuit Court of Appeals reached these conclusions. In Florida, Broward County allowed non-citizens to vote and deferred the removal of ineligible registrants for years out of sheer incompetence. The list maintenance requirements in the NVRA are gutted, particularly now in the 6th and 11th. It is ironic, since the NVRA owes its very existence to these same list maintenance obligations. Senator Bob Dole's compromise list maintenance amendment in 1993 broke a filibuster that would have otherwise doomed the bill, just as previous versions of NVRA died by filibuster before 1993. The Republicans made a deal to let the NVRA through in exchange for meaningful list maintenance standards. But the 11th Circuit generally held that if an election official makes an effort to clean voter rolls, no matter how shoddy, it's acceptable, and that best practices are not required under the NVRA. The proof is decidedly not in the NVRA pudding. The Sixth Circuit has followed the 11th Circuit. There, Michigan's Secretary of State Jocelyn Benson had over 25,000 dead registrants on the active rolls. A significant number of them had been registered decades after death, decades. In litigation, however, the Sixth Circuit interpreted the language that Congress passed requiring a reasonable effort to mean this, quote, a program that makes a rational and sensible attempt to remove dead registrants. A state need not, however, go to extravagant or excessive lengths in creating and maintaining such a program, unquote. Notice the court never says successful or effective. Results don't matter. The proof is not in the pudding. I do not believe this is what Congress intended. I do not believe Republicans would have dropped their filibuster with this limp maintenance standard, a mere rational attempt. Michigan Secretary of State Jocelyn Benson gets an A for effort from the court, but she deserved an F for outcome. Tens of thousands of dead registrants on active rolls? Never mind if someone's registered multiple times. Never mind if a registration record is missing the date of birth. None of this matters under these court rulings, only whether a state makes a rational effort. Results don't matter. This standard is not what the Republicans dropped a filibuster for in 1993. Congress can fix this. Many of the problems with American voter rolls occur at the point of registration, often by third-party groups. The voter may never know their record is botched because they can still vote. But then something changes. They move, they change their name, they get married, and the process creates a duplicate registration because the original mistake impairs a record match. It can even be triplicate. I've seen duplications reach 6 active registrations for a single voter in Allegheny County, Pennsylvania, Rashawn Slade. You can see all of his simultaneous registrations in the appendix to my written testimony. Some news. In Maine, we just found roughly 18,000 apparently deceased registrants, nearly 1,500 examples of intrastate duplicates, another 900 examples of interstate duplicates. The Public Interest Legal Foundation issued a detailed finding on this report on this data this month. Ironically, Maine passed a statute to fine the Public Interest Legal Foundation if we spoke about what we found on the voter rolls, including to you in Congress. The First Circuit struck down these speech penalties in a case that we brought under the NVRA. Ranking Member Morelli, even in New York, you find people that I describe in my written testimony registered multiple times, including one record we have right here. That means you're mailing extra campaign literature. You're wasting money on your campaign because of the state of the voter rolls. Finally, one way to improve list maintenance is for states to use commercial credit data to clean voter rolls, and I'm happy to answer your questions. Thank you.
The gentleman yields back. Appreciate your testimony. I'll now recognize myself for the purpose of questioning our witnesses. I want to start with you, Mr. Adams, if I can. I think one of the questions is, what is the federal standard and what is the role of the federal government in making sure that states are maintaining their voter rolls? And so if we go back and look at Section 8 of the NVRA, states are required to, quote, conduct a general program with reasonable effort, end quote, for voter list maintenance. And then the question would be, how does the courts interpreted reasonable effort? Can you give us a little color as to what is reasonable effort according to the judiciary?
Well, that's a terrific question, because as it stands right now, it just means make an effort. You get a participation trophy, right? If you do something, you succeed. But look what Congress passed after reasonable effort. In the language of the statute, it says to remove. There's actually an action verb, isn't there? It's not just make an effort, it's actually have to do something. And I think that's what the courts have improperly focused on.
And is it true in a court that, in a case that you were involved in litigating, the court came back and said that the reasonable effort is such a low standard that as long as one deceased voter is removed from the rolls, they've met their Section 8 obligations?
I think it's worse than that. As long as you have a program and you're doing anything, you satisfied what Congress tried to do.
So what should the standard be, knowing that the courts have effectively gutted out what I view as a reasonable standard? From a general program, should be something more specific. How do we redefine this to make it so that states actually have to do their job of maintaining proper voter rolls?
Yeah, the NVRA reads like a negligence statute, but in HAVA, the Help America Vote Act, there's strict liability. If you have any problems on the rolls, then you're violating federal law. The problem is only Attorney General has the right to bring a lawsuit. There's no private right of action in the NVRA.
I want to continue with you, Mr. Adams. So in the NVRA, are there restrictions on who can be removed? So if you have an individual, say that's not a U.S. citizen, this has come up, what are the restrictions on states from removing someone that they deem to be ineligible under the NVRA?
There really isn't a restriction on the state to remove a non-citizen. They have that freedom under our Federalist arrangement. The NVRA, however, doesn't reach non-citizens, meaning we can't bring a case to remove non-citizens under the NVRA. We tried. We found out the hard way. It doesn't fit.
So you don't have standing to go and do that. Who would have the standing to do that?
The Justice Department would potentially under HAVA, but Congress could expand the NVRA to reach non-citizens. That's easy. It's hard to imagine anybody would vote against that.
And so let's then maybe look at the state of Illinois. We know that according to the DOJ, 34 counties in Illinois provided no evidence of voter list maintenance. So the DOJ can bring forward that claim as they are in the Trump administration. But if you didn't have the Trump administration, it would simply be ignored because no one else would have standing, knowing the state is unlikely to go after itself.
Correct. You need somebody with the power to do something about it.
So if you have a completely Democratic state like Illinois, they're not going to move forward on this. If you have a Democratic administration or the Biden administration, they look the other way. We could get into a gerrymandering discussion with my colleague who was referenced in the opening statement. You want to look at a casebook study, I'd recommend looking at the congressional lines of Illinois, led by a fully Democratic operation, but that's not the point of the hearing today. But if we look at that, is it really but for, thank goodness, the Trump administration coming in and a Pam Bondi-led Department of Justice, that otherwise the state of Illinois would not be under any sort of review?
Or make it the state of Michigan. That's the real world example where the Secretary of State there has done nothing for a long time.
Well, we chatted with her in this exact hearing room not that long ago, specifically about the poor voter list maintenance in the state of Michigan. But you bring up a good point. In what scenario can a state remove a voter who has moved?
Well, that's a tough one, and Mr. Reamer talked about a bit. The NVRA has hurdles, statutory hurdles that they have to go through, like waiting, and it's all based on this technology from 1993, like the postman, right? And so the postman is given the power to keep our rolls clean or not, and really there's technology out there that this Congress could address.
So, got it. Well, I'd be curious, just from the other witnesses, is there any reason that you think that you could share with Ms. Haling why she shouldn't be allowed to vote?
Yeah, well, I don't think she should be allowed, but I can explain all of this. And she got railroaded by the county officials, is what happened, Ranking Member Morelli. When you passed HAVA in 2002, HAVA requires all registrants to have a unique identifying number. That's congressional statute, it's not complicated. What happened was North Carolina screwed up. When she registered in 2016, I think she said, in North Carolina, she gave them her number as required by HAVA, and they didn't put it into her record. That's what happened here. It's a typical incompetence.
But she's now gone through and rectified it, and now she's still on a list of 200,000 voters are being challenged.
Well, that litigation's over with. She's no longer being challenged. What's happened now is the United States has filed a lawsuit to get North Carolina in compliance with HAVA by going and harvesting those numbers for future elections. It's a classic example of a screw-up by an election official hurting a voter, and that's what happened here.
Mr. Adams, I'd like to return to you. One of the things you mentioned in your testimony was the third-party voter registration groups and the effect that they have on contributing in some places to inaccuracy or duplicate registrations. Would you elaborate on what those groups are, how they work, and how they affect this problem?
Right. These are the people with clipboards at community events or at the grocery store. And what we have found over and over and over again, the problems on the voter rolls are often traced back to third-party registrations, whether it's Rashawn Slade, which I would urge you to look in my written testimony in the appendix. He was getting registered to vote 6 times by third-party groups. Same with non-citizens in North Carolina. We trace those back in those reports to third-party registration groups. Look, there's a different incentive structure. They want to get as many people registered as possible, so they don't do a lot of quality control.
I'd also like for you to touch on, in your experience, some of the efforts and some of the lengths that elections officials go to in their communities to help ensure that voters are able to register and that registering to vote is an accessible and easy process for them.
Yeah, it has never been easier in the United States to register to vote than it is right now today, and it's never been easier to vote than it is today. And that's in large measure because of the diligence of a lot of election officials who pour a lot of time and money into making it easy to register and vote. That's why the registration and participation rates were so high in this last federal election.
Actually, Mr. Adams, thanks for being here today. What is the best practice for states to share voter identification roll with each other? And I will say this real quickly, and maybe my time might run out, apologize. You know, Social Security has a great pension. If somebody dies, you get a notice pretty damn quick that you're not getting your benefits. Why can't we tie that to voter rolls? Wouldn't that be an interesting concept? But anyway, I'll let you answer your question.
The best is commercial data. Commissioner Don Palmer at the EAC has advocated for this. I'm on the board of advisors of the Election Assistance Commission. We have advocated at Public Interest Legal Foundation, use Experian. Commercial data is the most accurate. There's a cost, but we can figure this out.
Mr. Adams, I know there's a lot of information here, but why is transparency when conducting voter list maintenance important?
Well, that's what Congress put into the NVRA so we can look. And we brought cases. We won a case in the First Circuit Court of Appeals for transparency. We just have a case in the Fourth Circuit on appeal where we beat South Carolina because they actually don't let anyone look at the rolls unless you're a registered voter, which totally violates the NVRA. Without transparency, you can't know what's going on, and that's why it's so important.
So let me ask you, do the jurisdictional differences in list maintenance practices ever become troublesome when looking at efforts from a legal standpoint?
Oh my gosh, there's a huge gulf between what states are doing. Some very innovative secretaries of state, for example yours, are using data sets that they wouldn't even think of in other states. So there's wide differences across the country in what they do.
Now, I know what our Secretary of State would say if I asked him this question, but I'm going to ask you. Should more states adopt Ohio's method of voter roll maintenance?
Well, I can name Michigan on a start. There's the top list. But there's other states that desperately should get up to Ohio standards that aren't even close. New York. Look, New York has enormous numbers of people without Social Security numbers or the HAVA mandated number in their database. And that's why I said the ranking member is going to have to mail campaign material wasting money because the voter rolls are messed up over a simple error.
Mr. Adams, what is required under the reasonable effort standard for voter list maintenance?
Well, almost nothing, and that's what in my written testimony you'll find the Sixth Circuit Court of Appeals ruled if you have a program, it's good enough. It doesn't matter if the proof is in the pudding, it doesn't matter if it's effective. One thing Congress might do on the data that you just talked about, Congressman Miller, is when I was at the Justice Department, I brought the case of United States versus Alabama, and I brought the case of United States versus Vermont. And those two states were not reporting the data that you were just talking about, but it's only for UOCAVA voters, for military voters. There's no obligation in the statute to report those data for regular voters. Congress just left out regular voters when they did the NVRA for the EVE survey. That's what you're referring to, it's EVE, the Election Assistance Commission. You might extend that to the entire survey, that states have to do that. It's optional. They don't have to report any data unless it's a military voter.